Self-deporting comes with a major cost, and doing so could destroy your family for decades. And I know this because I've been practicing immigration law for over 20 years, and I've seen so many people make these mistakes that cost them their future. If you're undocumented and thinking about leaving voluntarily to do things the right way, you're about to trigger the 10-year bar that will separate you from your family for a decade. And the thing is, most people don't know there's a specific legal strategy that can bring you home, but it only works if you prepare it correctly. Which is why in the next 10 minutes, I'm gonna show you exactly why self-deportation is a trap and the exact waiver strategy that I've personally used to reunite families and give them a better future. Most people don't understand that when you leave the United States after being here illegally for more than 1 year, you trigger something called the 10-year bar. This means you're barred from returning to the United States for 10 years, even if you have a US citizen spouse or children who want to petition for you. But what gives me hope for families facing this nightmare is that there's a legal waiver that can overcome the 10-year bar if we can prove that your US citizen or permanent resident spouse or parent would suffer extreme hardship without you. So when people ask me, should I just leave and come back legally? I tell them the only way you can come back legally now is if we could prove extreme hardship to your qualifying family member. Otherwise, you're looking at decades of separation. Let me tell you about Carlos, who had contacted my office in 2019. He had been in the United States for 12 years, had a US citizen wife, and 2 US citizen children. His previous lawyer told him he needed to go to a consular interview in Mexico to get his green card, but never mentioned the 10-year bar or the waiver option. Carlos left voluntarily to attend his interview. The moment he left the United States, he triggered the 10-year bar because he had been living here illegally for more than 1 year. At his interview in Mexico, they told him he was banned from returning for 10 years. But where Carlos's story could have been different is if his previous lawyer had prepared a waiver application showing the extreme hardship his US citizen wife would face without him, Carlos could have overcome the 10-year bar before he left and returned to his family. We filed a different waiver application. We were able to get him a green card to come back to the United States to be with his family. We documented the financial struggles, the emotional trauma, the medical issues caused by stress, and the major impact separation had on his spouse. The key to the waiver is proving extreme hardship to a qualifying relative, your US citizen or permanent resident spouse or parent. This isn't just ordinary hardship that any family would face during separation. It has to be extreme hardship that goes beyond what most families experience. But here's why having the right legal strategy before you leave is so critical. The 10-year bar waiver could be a lifeline for families, but it requires proving extreme hardship to your US citizen or permanent resident spouse or parent. And the way you prepare this case can determine whether your family is reunited quickly or separated for decades. Here's how the waiver works. If you could prove that your US citizen or permanent resident spouse or parent would suffer extreme hardship if you're not allowed to return, the government can waive the 10-year bar and let you come back to the United States. Extreme hardship can include medical conditions that require your care, financial hardship where your family depends on your income, emotional hardship from separation, or country conditions that make it more dangerous for your family to join you outside of the United States. The key is documenting everything properly. We need medical records, financial documents, psychological evaluations, country conditions reports, comprehensive evidence that shows your family member's hardship goes beyond normal separation. But there are 2 different ways to file this waiver, and choosing the wrong one could add years to your separation from your family. You can file the waiver after you leave the United States and get denied at your consular interview. This is called a 601 waiver, or you could file what's called a 601A provisional waiver before you leave the United States. The 601A provisional waiver is much better because you can get it approved before you leave for your consular interview. This means you know you can come back after you leave because the 10-year bar is pardoned. If the provisional waiver is denied, you can stay in the United States and try other options. But if you leave without a provisional waiver and file a 601 waiver after being denied, you're stuck outside the United States while the waiver is pending. This could easily take 1 to 2 years, and if it's denied, you're stuck outside for the full 10 years. But there's actually a very important thing about these waivers, which is why you absolutely need expert legal help to win them. The extreme hardship standard is very high, and the government denies most waiver applications because they're not prepared properly. You can't just say your family will miss you or that separation is hard. You have to prove that your spouse or parent will suffer hardship that goes far beyond what most families experience. Many people make the mistake of thinking they can show hardship to their children, but hardship to the children is not considered in this waiver. I recently won a waiver for a client whose US citizen wife had diabetes and depression. We documented how her medical conditions worsened during his absence, how she couldn't afford her medications without his income, and how the stress of separation was literally going to kill her. The waiver was approved and he was able to return to his family. If you're thinking about leaving the United States for consular processing, don't do it without exploring the waiver option first, because the difference between a properly prepared waiver case and leaving without one could be the difference between months of separation and decades apart from your family, which is why you need to call our office right now at 973-934-5854. We specialize in 10-year bar waivers, and we know how to prove this extreme hardship. We offer same-day consultations for only $50, so don't trigger the 10-year bar without a plan to overcome it. Call us now at 973-934-5854. But here's what makes these cases even more urgent now, and why waiting could make your waiver case much harder to win. The key to a successful waiver case is starting the preparation before you leave the United States, not after you're already stuck outside the country for years. When we prepare waiver cases, we walk you through the entire case, covering the extreme hardship that your family member would face if you had to leave. The strongest waiver cases are the ones where we can show that separation would literally be life-threatening for your spouse or parent. We also document how your family member couldn't join you in your home country due to safety concerns, lack of medical care, or inability to work and support themselves there. But there's one more type of hardship evidence that's particularly powerful in waiver cases, and most people don't think to document it. The most powerful waiver cases often involve US citizen spouses or parents who have medical or psychological conditions that require your specific care and support. We document not just that they have these conditions, but that you are their primary caregiver and that no one else can provide them the care that they need. For example, I won a waiver for a client whose US citizen mother has Alzheimer's disease. We documented that he was her primary caregiver, that she didn't recognize other family members, and that placing her in a nursing home would have been devastating to her condition. The waiver was approved because the government recognized that his mother's survival depended on his care. But the most important thing about waiver cases is that timing will make or break your chances of success. The best time to prepare a waiver case is before you leave the United States, when you can file the 601A provisional waiver. This way you know you can return before you trigger the 10-year bar. But even if you've already left and you triggered this 10-year bar, it's not too late. We could still file a 601 waiver to bring you back. The key is having comprehensive evidence of extreme hardship and expert legal representation that knows how to present these cases. Every month you wait to file the waiver is another month of separation from your family. Every month is more evidence of the ongoing hardship your family is suffering, but it's also another month of lost time together. The 10-year bar doesn't have to mean 10 years of separation if you have a qualifying family member who would suffer extreme hardship without you. Make sure to call our office before leaving the United States. I'm here to give everyone life-saving information to protect their rights in the United States. Right now, ICE has 70,000 subscribers on social media, and I need your help to get more subscribers than they have. Every subscription helps us reach more families with life-saving information. If you believe knowledge is power and that families deserve to know their rights, hit that subscribe button now and help us beat ICE's subscriber count. So now that you know that self-deportation triggers this 10-year bar and how waiver strategies can reunite families, there's something even more urgent you need to prepare for. What happens if ICE finds you before you could execute your legal strategy to leave the United States properly? So watch this next video on screen right now, where I tell you exactly what to do if ICE stops you, because knowing your rights during an encounter could buy you the time needed to pursue the right legal path instead of falling into the self-deportation trap.